Okay, so the first time I tried to upload this video, it came back and said blocked, and I've never had a video get blocked. So it was either the footage of James White or of True TV. So this first footage of James, I just kind of, it's going to be all blurry and whatever. The audio is still the same, but the True TV footage, I filmed my TV. So you motherfuckers can't copyright this shit, okay? This is going to upload. Okay, my bad. All right, here we go now. Here we go. So like about 5 or 6 of you guys told me about this, and because I put my video out or whatever, and it was really not about this whole thing, but this guy James White is one of my, actually he is my absolute favorite YouTube. I wouldn't say that. He's like my favorite actual analyst. You know what I mean? Because it was a cop and he was a prosecutor, and now he's one of us. You know what I mean? Like he is probably the most valuable informational source of either side of any police interaction that we see. You know what I mean? So I really, really, really respect this guy and like his style. But I do disagree with him about this case. So I'm gonna let it play, and I'm gonna stop him right where I have the disagreement. Oh, and James, if you watch this, tell me why you think I'm wrong. If you think I'm wrong, I mean, you know what I mean?
On patrol at infraction. Now, in the absence of pretext, what other reason would there be for a Mansfield police officer on patrol at 12:45 a.m. to conduct an investigatory detention?
After how I explain how I think you're wrong, or when I explain how you're wrong, I'm going to answer this, and it's a really, really good answer. I know it's a rhetorical question, but I have a great answer for this.
For an offense like jaywalking, it's obvious that there's pretext or ulterior motives. Now, the United States Supreme Court case of Wren tells us that pretext does not matter. But what is lost on these room temperature IQ police officers?
I know what he's trying to say here, but if my AC is not working, the room temperature is like 90 in my room, and I think that's given them about 25 too many points on their IQ. But anyway, carry on, James.
Is that in the same way that it's not illegal to have ulterior motives, you also cannot create the scope of your investigation around those ulterior motives. The scope of your investigation has to be what you stop the person for until you're able to develop reasonable articulable suspicion of some other criminal activity and then pivot. It's no different than a traffic stop under Rodriguez, right? Rodriguez says you stopped them for a taillight out. Your job is to focus on the taillight out unless something happens along the way in your process where you develop good enough RAS that you could stop them on the street for something different. So if you're up to a car and you smell marijuana and marijuana is illegal, okay, now you have your RAS to pivot to a marijuana investigation. If you smell alcohol and they're operating a car, okay, now you have your RAS to pivot to a DUI investigation.
Although I think that's all. And when I say bullshit, I don't mean it's bullshit that it's... What he said is correct and true and exactly the way it really is in reality. But what I'm saying is I think reality is bullshit when it comes to that. But the idea there, and the reason it is like that, is because an actual criminal who would be doing something wrong, if you do stop them for whatever little minor infraction or whatever, you're going to be able to find something, right? There will be some weed in their pocket, or there will be, an empty container somewhere. Like there will be something like that, you know what I mean? So I understand it, but I just don't like it. But anyways, now he's talking about specifically what happened in the Mansfield one.
But this is the situation that we're in. This person is stopped for jaywalking. That means that the scope of Officer Nelson's investigation is jaywalking. But Officer Nelson believes, improperly, that you can get in somebody's pockets simply because you're out with them. And that's not how it works, right? So just break it down to a completely elementary level. You stop somebody under Terry. It's a Terry stop. You do not get to conduct a Terry frisk, which is what Officer Nelson was trying to do here, unless you have some objectively reasonable information that Roberts is armed and dangerous. Okay, so the first screw up that Nelson makes here is that he gives Roberts a command to put his hands against this vending machine. The issue is he doesn't have the authority to give that command. It's not a lawful order. So Roberts says no.
Okay, and here's where I disagree completely, because I don't think they had a reason even to be out with him, right? They could mask it as a consensual encounter if they wanted to, but what I think is the fact that the officer claimed to have been a witness to him crossing the street, and then as soon as the old man put a stepped foot on the other side of the street, all suspicion of any crime should have been dispelled at that point, right? Because if you look at the if you look at the jaywalking laws, and I've read all the ones, all of them, dude, even past ones like the legislative history ones, and they all basically say if you cross the road and you create some kind of you change the path of a traveling vehicle, like a car has to brake because of you, or a car has to swerve out of your way, or you stand there and let the car hit you. Either way, you're guilty of jaywalking, right? And they all say that there has to be some kind of disruption of traffic, or that somebody has to complain of some disruption of some traffic. But the fact is, they had the only thing that was giving them a reasonable suspicion of any kind of jaywalking crime is the fact that he said that he crossed the road and that he's on the other side of the road. Well, it dispels the suspicion of that crime, because they have had no calls about anybody crossing the road. They've not received or seen a dead body in the road or a smashed car. There's no objective evidence of any jaywalking, right? Or subjective. There's no complainant, right? And they even have a witness to him crossing the street and successfully making it to the other side. So that cop who witnessed that is actually a witness in to help his defense against this, because you can ask him, did you see any other cars? No. Well, did he make it across the road? Yes. Well, then there you go. You know what I mean? And so the cops that are on scene see him on the other side of the road, and the cop that called him in and said that he saw him cross the road, there's your witness. You have proof that he did not jaywalk. Here's the thing. It's all about the least intrusive way or whatever. Why would you have to stop somebody and question them about jaywalking when all the information that you need is right there next to you? All you got to do is look in the road or talk to the cop and then talk to dispatch, and you can do all your investigation to find out if this dude jaywalked without talking to him. You know what I mean? That's what I'm saying. Like, you know what I mean? And the only other thing that says it in those jaywalking laws is that if you're not in the crosswalk or obeying the crosswalk, that if you are handicapped, you're exempt from having to walk to the crosswalk. Like if it's 10 feet away and you can't do it, then you're exempt from it. You know what I mean? They literally, what he's using as a reason to talk to this guy is the reason they should not talk to this guy at all. You know what I mean? On top of that, the other couples like A, B, C, and whatever, the other couple that say or make it sound like you're not allowed to cross the road in any other place other than a crosswalk, all say that you have to yield the right of way to a vehicle. Okay, at a four-way stop, you yield the right of way to the person to the left of you, right? But then after they go, then you get to go, right? So if you're yielding the right of way to a vehicle, you just stop and let them go, then you can go. You know what I'm saying? And since I'm not an attorney, I have to show everything that I'm talking about. So here are the laws that... Okay, so this one says, when the traffic control signals are not in place, or if it's not operational, the driver of a vehicle shall yield the right of way, slowing down or stopping if necessary to yield to a pedestrian crossing the street or roadway within a crosswalk when a pedestrian is upon half of the street of the roadway upon which the vehicle is traveling, or when the pedestrian is approaching so closely to the opposite half of the street or roadway as to be in danger. All right, so that's on the driver. You know what I mean? That didn't happen. And this is what I was talking about. Unless you're hit by a car, you're pretty much good, because it says no pedestrian shall suddenly leave the curb or any other place of safety and walk into the path of a vehicle which is so close as to constitute an immediate hazard. For example, he could do that and not get hit, but if the car fucking had to slam on his brakes and swerve, well, there you go. You'd have evidence. There'd be a bunch of skid marks on the ground, and probably a complaining driver saying there's a crazy person walking across the road. I almost hit the motherfucker. Go arrest him. You know what I mean? That never happened. It says that pedestrians should be subject to traffic control signals as provided in paragraphs, right? Well, I mean, think about if you're just crossing the road in the middle of the road in between two traffic signals and both of them are green. You can cross the road, you know what I'm saying? Like, not going across the road that way, but I mean, in the middle of the road of a section of street that on either side has two traffic signals, you're good to go. Here are the ones that I think are relevant now. I don't know for sure because I don't have, Westlaw and all that bullshit. So I'm just kind of going off guess here, but I don't use the AI bullshit. So I'm pretty sure this is good. But it says no pedestrian shall suddenly leave the curb or other place of safety or walk or run into the path of a vehicle, trackless, trolley, or streetcar, which is so close as to constitute an immediate hazard. Obviously, he didn't do that, right? And then it says this section does not apply, blah, blah, blah. All right, revised code. And this is saying when a pedestrian is crossing in the proper, intersection, crosswalk or whatever, that if a car stops to allow him to do that and yields his right of way, another car can't come from behind him and go around that car. You know what I mean? It needs to yield the right of way as well. This is just all penalties for violating what I was just talking about, if you were to violate that. But okay, I got it now. This is the authenticated PDF, baby. All right, check it out. And it's very short. June 30th, 2025. All right, brand new, baby. It says every pedestrian crossing a roadway at any point other than within the marked crosswalk or within an unmarked crosswalk at an intersection shall yield the right of way to all vehicles, trackless, trolleys, streetcars upon the roadway. Again, where it doesn't matter where you are. Look here, for example. This is the exact intersection of where the guy was crossing, and that red dot is where his Coke machine was or whatever. This is the exact one, right? The exact street on Google Maps. It says every pedestrian crossing the roadway at any other point than within a marked crosswalk or within an unmarked crosswalk at an intersection. Any point not including a marked crosswalk or an unmarked crosswalk. So like, for example, right here, shall yield the right of way to all vehicles, trackless, trolleys, streetcars upon the roadway. It doesn't say it's illegal to cross right there. It just says you have to yield to the other vehicles. Next one says any pedestrian crossing a roadway at a point where a pedestrian tunnel or overhead pedestrian crossing has been provided shall yield the right of way to all traffic upon the roadway. That wasn't the case or whatever, so that doesn't apply. Okay, now here's the only one that says anything about not crossing except for in the crosswalks, right? And that's where adjacent traffic signals are in operation. Pedestrians shall not cross at any place except in a marked crosswalk, right? So highway traffic signals are depicted by Google Maps, but like this thing right here. So we have to zoom out and look at adjacent intersections to see if they have traffic signal lights, right? So if you zoom out, not a single one of them does. Not a single one. So you see here, there's no. So I don't see how. Anyways, I just don't see it. The cops could have dispelled any suspicion just by standing where they were and looking and talking to each other and calling dispatch to double check. I mean, there's no reason to talk to this guy at all. Now, I'll tell you my reason for it is I think they knew who he was. Well, I know they knew who he was. They said that, but it's more devious than we thought. And I'll get to that, but I just want to talk about Terry versus Ohio for a little bit and give a message to everybody about cops and cops about everybody. And I don't know, basically just... Anyway, here it goes. Terry versus Ohio and cops. So everybody and their mom has a idea of what they think police should do or what they think their job is, and almost everybody and their mom tells police what they should do and what their job is. And I understand that it gets frustrating for police, and I understand it's even more frustrating for us because we can clearly see what the job is. They can clearly see what the job is, and nobody's doing their job, right? Well, I just want to tell you, everybody who's ever told a cop that he's doing his job or how he should do his job is wrong. And every police officer in this, latest century or whatever that says I'm doing my job is fucking wrong, okay? Put it this way. If you arrest somebody, at any cop, policemen everywhere, if you arrest somebody, you have failed at your job, right? Arresting somebody is not the purpose of police, all right? The purpose of police is to make sure that people are safe and that the peace is kept. If you arrest somebody, that's a side effect of you doing your job wrong. The powers of arrest weren't given to you so you can go arrest people. It was given to you just in case something out of your control goes crazy, like you aren't able to control yourself or your job or the people around you, then you can arrest them. You know what I mean? Otherwise, you need to keep them out of jail. Every time you arrest somebody, you're doing something wrong, okay? Or that means something has gone wrong. You're unable to keep the peace. You can't keep people in control. You're doing your job wrong when you arrest somebody, okay? Think about that. That's the absolute fact, right? An arrest is a side effect of you doing a bad job. So I just want to talk about three things. Terry versus Ohio, Pennsylvania versus NIMS, and Maryland v. Wilson. These are three cases that are all extensions of each other, but they all start with Terry versus Ohio. Now, Regardless of my diagnosis of any of these and how it's affecting people, one thing's going to stay the same. Even if these cases get overturned or considered moot or null and void, the police are going to
do it anyway. We're gonna 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 do it anyway.
Basically, I just want to get across the general idea that using slang or using a certain police term or whatever you want to call it, code language, is an attempt to circumvent laws and rules that are made up by people who make up laws and rules, right? Like if you make a statement and then you put the word no at the end of it or not in front of it, then everything you say becomes the exact opposite of what you meant. You know what I mean? So it's that kind of idea, dude. And cops are really good at this. Like, for example, in Terry, Ohio versus Ohio, 1968, they had this small debate about what a stop and frisk is, right? Of course, the police's lawyer is trying to say that the Fourth Amendment should be implicated because it's a simple stop and frisk, not a search and seizure. So we shouldn't even think about the Fourth Amendment because a stop and frisk is a illegal search and seizure, right? Stopping somebody is seizing their person, and frisking somebody is just another word for searching them, right? Because in a stop and frisk turns into a find and arrest, right? It's the same thing, right? A search. Anyway, so they debated this, and they said the distinctions of a classical stop and frisk theory thus serve to divert attention from the central question under the Fourth Amendment, the reasonableness and all the circumstances of a particular governmental invasion of a citizen's personal security. So they're acknowledging, the court is acknowledging that using the term stop and frisk is to take your attention away from the fact that they're possibly violating your Fourth Amendment. And also they say of a particular, meaning no matter what, this isn't a blanket thing. It's each individual instance. And another thing that the court did, or the Supreme Court to do, is talk a lot, which, again, I used to not like, but I do now. And one thing they said in this one is, and also, too, they really use, not slang, but they use the kind of general idea of the times, right? And this is in 68, right? So they said that the Fourth Amendment is not a talisman, and which confused me because I wasn't sure what a talisman was. So I looked it up, and of course, the first AI definition just said it's a ring or a rock inscribed with good luck on it, or that gives you good luck. And I said, that doesn't make any sense. Why would they say that? You know what I mean? It doesn't make any sense telling the cops that the word search and seizure is not a talisman. If it's something that brings you good luck, they would want that. You know what I mean? So anyway, after I looked at the second definition, I learned that a talisman also adverts evil. The Supreme Court is literally saying that they know that the cops are bad, or like, you know what I mean? Or that the cops are in general, a bad force or, presence to be around. I think that's very, very telling. This court that came up with this decision literally uses the N-word, like the racist N-word. I'm dead serious. Even moreover, in the context that they use it, it's even worse because they're saying that the black people complain of police harassment, and they're saying that it's not going to change. They literally say it's not going to, that the cops are going to keep harassing black people regardless of how we categorize this. Well, and they were talking about the exclusionary rule. They were basically saying if we look at this as just a whatever, or we make a ruling on this based on the exclusionary rule, that if we exclude this evidence as a violation on the Fourth Amendment, it's not going to change the cops come into your house and fucking with you. You know what I mean? So it's crazy to me that they can put that little side in there and still make a decision based on exactly what they said they shouldn't. You know what I mean? It's just fucking stupid. But they also distinguished between regular police or good police and bad police, basically, and racist pieces of trash. They said that it was only certain elements of the police community, right? So an off-duty racist cop, you know what I mean? So they're saying an off-duty racist cop is still going to come fuck with a black dude on the street regardless of any decision we make, you know what I mean? Which, again, is telling, like, they're telling us what's going on now and it's probably going to happen in the future, and they're kind of aware of it. Like, so I like the fact that they overtalk. And the police don't like to take complaints about themselves is because here in this one, this is the time when everybody was racist, and the court says that the Negroes frequently complain about, police fucking with them, and then comes to find out, like, frequent complaints are evidence of actual facts. you know what I mean, or of actual problems, right? So if there's frequent complaints about the cops, 20 years from now, we might find out that what the cops are doing was actually wrong as fuck, because, I mean, the Negroes frequently complained about the cops, and we have now since found out that the cops are evil, racist pieces of trash, dude, and if it wasn't for those Negroes complaining, how would we know? You know what I'm saying? And like, so not to say we fixed that or anything, but I'm just saying that maybe they drew the line between frequent complaints becoming actual allegations and actual things that are happening. You know what I mean? So maybe they don't like to take complaints about themselves. I don't know. Here's the point I'm trying to make. In the same decision that people rely on to allow police to do what they're doing, right? Terry versus Ohio says that we should not shy away from the words such as stop and frisk to not mean search and seizure, because they obviously do mean search and seizure. They're minimizing. They're telling the cops not to minimize the word search and seizure and make up a different slang term for it and say that it's not the same thing, when in reality, in the same decision, the Supreme Court is minimizing unlawful murders of black people to just be simple complaints, right? And the continued abuse and murders of them to be called harassment, right? You know what I mean? They're kind of minimizing the whole thing. So whenever cops, at a time when cops are routinely, accidentally killing black people, right, and their family members go redress their grievances to their government, this court is saying that routine killings of black people are now considered, when their families come and talk about it, are considered frequent complaints, right? It's the same thing they're telling the cops not to do and call a search and seizure a stop and frisk, right? They're saying you can't do that because it's obviously a Fourth Amendment thing. But whenever the Negroes frequently complain about police harassment, that it's just that, right? Give me a break, dude. I'm serious, man. I can't make this shit up. But on a serious note, it would make sense that the Supreme Court would be able to call this type of behavior out and call a spade, is because they're guilty of the same type of behavior, so they know how to recognize it. See, with the word arrest and detainment, they're doing the exact same thing in today's culture. Like, they're saying, oh, you're detained. You're not under arrest, you're detained. Right? And then you just get taken to jail. Like, they don't use the word arrest because detained, it doesn't sound that they're two different things, right? Or at least you think so. But anyways, and that's what I mean when I say they're going to do it anyway. Like, you know what I mean? Even if Terry gets overturned, and even before, the whole reason Terry versus Ohio exists is because cops were already doing this, right? And it's just the court even said that it was a theory, and that the stop and frisk, or the classical stop and frisk theory, does it, blah, 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 blah. So they literally have been doing it for so long that the court was calling it classical. You know what I mean? It just didn't reach the court until 68. You know what I mean? So they were doing it before and after Terry, Ohio. They're going to continue to do it even if it becomes overturned. What I'm saying is the only value that Terry versus Ohio has is what other people or what the cops think they can do with it, not what the actual decision is, because obviously they're not going to follow it. And they're just, anyways. In two sentences, also, two very important sentences I think that everybody overlooks, is they specifically give you specific instructions that the objective facts behind any one of these kinds of cases needs to be looked at from an objective standard. Like, you have to look at it from an objective standard. But in the same sentence, it also explains the viewpoint a judge should have as detached and neutral scrutiny of the judges must evaluate the reasonableness of a particular instance of a search and seizure in the light of the particular circumstances. And in making an assessment, it's imperative that the facts be judged against an objective standard. See, I don't know how people stick on whatever parts of decisions that they do to get whatever they want or whatever behavior they want to be allowed to do out of things. But that right there, what I just read, tells us that the officer safety thing, like in the name of officer safety, like, no, I'm sorry, officer safety, you know, like it's a greeting. Hello, officer safety, get out of the car. You know, like, it tells us that you can't do that. Like, that is the one. It says particular, like each particular situation in a particular set of circumstances. Like, literally, it has to be the safety of that particular officer that is actually in danger. You know what I mean? Or you in danger, or you and the officer, by sitting on the side of the road. It's literally telling us that this whole officer safety mentality thing should not have ever happened. Again, they're going to do it anyway. You know what I'm saying? Whatever I love that shit. Right, as the fact should be. But it also says, well, earlier I said detached, neutral scrutiny of a judge, right? And that's super important. And also a objective view by a judge and in the particular particulars of facts of a certain situation or circumstance need to be looked at and viewed with a neutral, detached scrutiny for both. You know what I mean? Through the eyes of somebody that's not a cop. You know what I'm saying? Okay, and I just want to tell everybody, the reason I'm basically doing this is because I also want you to see that those Mansfield, Ohio cops were targeting this guy. And it's not just because of all the reasons that I put forth in the video before, right? And the obvious conspiracy that was against him, but also, too, the term jaywalking, it was a not racial, but it was a slur for people who were so stupid that they would walk into the road and get hit by cars, right? And then the government, and I'm going to show you a video on this, but the government came up with a way to make the car, okay, for example, like they made the road illegal to stand in, and if you were standing in the road and a car changed its path of travel because of you, then it was your fault and you were found guilty. You know what I mean? And you were the one guilty of a crime, right? Because, anyways, just like with any new thing, whenever the automobile came out and they started to flood the roads with automobiles, right? And they started killing people and hitting people, what's the first thing they did was say, well, there's got to be something wrong with the automobiles. Let's ban automobiles, right? It's retarded. But eventually they came up with what they came up with. And I'm going to stop talking and just give you the history of it so I can explain what they're doing now with it.
A century ago, the city street was a public place that was open to everyone. It was shared by pedestrians, horses, and weird old-timey bicyclists alike. Not to mention streetcars that took people to work.
Now, Teddy, you'll have a fun day at the sweatshop. And remember, always walk in the street. It belongs to all of us.
But when the car was invented, people started driving them at top speed through the crowded streets, and the results weren't pretty.
My boy! He's dead!
Oh dear! So that's what happens when one's motor car strikes a peasant.
Naturally, everyone blamed the new invention for the carnage.
7th kid mashed by a metal death machine this week. Maybe these things shouldn't be allowed.
Public outcry grew.
Extra, extra! Innocent boy killed by automobile!
And some cities even discussed passing laws against them.
We propose that the streets not be filled with these high-speed 2-ton metal projectiles.
Here. Pay our taxes.
Yeah, pay our taxes.
They're killing us out there. Well, technically, we're killing them, Bill.
Oh, good point. We gotta fight this thing.
I got it. We'll tell them the streets are for cars only, and if a car kills you, it's your own fault.
And we'll give the folks that walk in the street a really humiliating nickname.
What about Irish walkers?
Now that's pretty cruel, but we can do better. I got it. Jaywalkers.
Oh, you disgust me. And I love it.
It doesn't mean much to us now, but back then, Jay was a really offensive slur. It basically meant dirty hillbilly, which makes this really messed up. Like, what if today we called them walkers, or even walkers?
Hey man, come on, there's a kid on set.
Yikes, sorry. To publicize their new insult, the auto industry actually planted stories in newspapers blaming pedestrians for automobile death.
Extra, extra! Lame brain jaywalker flings himself before noble automobile.
My boy? Jay?
Serves them right, I say. I hate those good-for-nothing Jays.
So do we all, sir.
Me too. I hope my stupid Jay son rots in hell.
Today, jaywalking is a crime, and in fact, most of our modern traffic safety culture descends from this kind of blame-shifting propaganda.
Now, I want everybody to think about this, okay? He just said, today, jaywalking is a crime. But for a crime, you need to have an actual victim, right? Or at least somebody complaining about what you're doing, right? Walking is a cop seeing you walk across the street. Doesn't have that. So why would a show that is all about uncovering and exposing this whole debacle about auto companies creating these stories so police would make laws or whatever? Why would they call it a crime? In today's, definition, if it's not a crime, right? They wouldn't, because it would be a crime in today's definition if he crossing the road had caused an automobile to brake or to change course or something like that. Otherwise, it's not anything. You know what I'm saying?
And in fact, most of our modern traffic safety culture descends from this kind of blame-shifting propaganda. Think about it. A group of private businessmen coined an offensive slur to promote their product, and it worked so well that today it's a legal term. That's like if the trash can industry convinced us all to call littering dropping.
Seriously, dude, do you even think before you speak?
You know, funny, I don't. As a result of this campaign, the street went from being a public place where everyone was welcome to a terrifying off-limits death trap.
Stay back, Ethel. The streets belong to the machines now. Thank you for granting us passage, Metal Majesty.
It sounds silly, but cops literally employ this idea all the time. Like, if, for example, if they fall under scrutiny for shooting a unarmed black man running away, then, you know what I mean, a week later, then all the crime is like in these black communities. Or, for example, how about this one just most recently, if you are a corrections officer and you handcuff a man and have 11 of your friends spit on him, kick him, punch him, and just beat him to death while he's in handcuffs. Robert Brooks. Well, now the whole prison system, the whole New York prison system is under scrutiny. So what do? They go on strike, right? So let's say sometime back in April, you know, this guy crosses the street and they make this whole big deal about him jaywalking, and then, you know, fake take him to the ground and do the whole pinch and poke until he fucking breaks a bunch of ribs, right? And then now the cops in the neighboring city find out about this, so what do to cover it up, right? Or to not cover it up? Basically minimize a bunch of broken ribs, right? So if somebody dies crossing the road, well then you save that guy's life, really. They just take their state patrol car and ram a random jaywalker. Now they can say, oh look, the police were saving that man because look what happens whenever you jaywalk, you get killed. You know what I mean? It's fucking stupid. Oh, here is a map of Ohio, and here is a headline that I found in I wouldn't say newspaper, but a social media source or whatever, a media source in the city over here. It says, pedestrian killed after being struck by Ohio State Patrol cruiser on I-71, Medina County. And, of course, now it's under investigation. This was in July, and this was just 2 months after the incident in Mansfield, you know what I'm saying? So, I mean, I don't know, man. It just seems to me like the cops are just doing the same old thing over and over and trying to employ the same old mental gymnastic tactics that they do, and it's just stupid. And this is why the cops the cops use the term jaywalking like on scene a bunch of times. The news keeps using the term jaywalking when it's not even a real thing. There's no crime of jaywalking, but when you Google it, it says this. Which, I mean, you can read it, but it's super misleading you into thinking that jaywalking is an actual crime. It's not. But the cops know and the news knows that if they don't know what jaywalking is or they want to get the definition, that people are lazy and they're just going to Google it and read this, and then it's going to their investigation of what jaywalking really is, or, you know, their personal investigation to get more knowledge is ended with this right here, right? When in reality, the dude did not jaywalk and didn't show any signs of it. In fact, the fact that he was standing there on the other side of the road means that he didn't jaywalk. And again, it's like the reasonable suspicion thing, ... of a crime. This definition is leaving out the fact, because it says jaywalking is defined as crossing a roadway at any point other than a marked or unmarked crosswalk at an intersection. No, it's not. It's crossing at any other point not in a marked or unmarked crosswalk and not yielding the right of way to the other vehicles. Once again, the right of way. Once you yield the right of way and the vehicle has gone by, you have the right of way. It doesn't say anything about jaywalking at all in the statute. It's pedestrian in the roadway. And unless you walk in the path of a vehicle or obstruct the vehicle and get close enough to where it's considered a hazard, and you don't yield, then yeah, fine. But it's not defined. This is half of a definition, you know what I mean? And it's bullshit, dude. And I think this needs to stop, and I think everybody is fucking stupid for thinking that you can jaywalk or thinking that something's illegal about crossing a road that has no cars on it in the middle of the night with one fucking traffic control device that we don't even know if it's working. I think it's retarded. I think y'all are all stupid. I think those cops are even stupider, and I'm the smartest person on the planet. Good night. Okay, I'm just kidding. I'm not done yet. And think about this, too. Why are they even using the term jaywalking? Like, if you weren't trying to employ the faculties of that word, like, for example, trying to accomplish the same thing that the automakers did when they started and originated the term jaywalking, if you weren't trying to do that, why are you using the term as opposed to, I don't know, playing that little video that I just played and letting everybody know the term jaywalking is where it came from, you know? If you weren't trying to employ the, results of that, then why are you using the term anyways? The only reason to use that term is to let people know where it came from so we don't make that mistake again or have other people do the same thing to us, you know what I mean? Why are you using that term in the context that it was meant for when these, people with malicious ideas and whatever thoughts and their intent for that word had and made up. You know what I'm saying? Now, I'm going to go back to the stop and frisk thing, okay? The stop and frisk is, well, at the time was what the cops did to everybody, right? Okay, and the Supreme Court is saying that you can stop and frisk somebody as long as you have the reasonable, articulable suspicion of some kind of crime, right? And then you stop and frisk them only long enough to either find that that's the person that you're looking for or not. So literally, the stop and frisk law, the reason that they're allowed to detain somebody briefly for a stop and frisk is to exonerate them of whatever it is they're accused of or think somebody's accusing them of, right? Okay, so if you think about the stop and frisk or search and seizure that way, then it's fine. You know what I mean? And it's the same thing here. Like, they're distorting what the actual purpose is. The purpose of the pedestrian and roadway traffic or jaywalking laws are so people don't get killed and cars don't kill people, right? If you think crossing the road and darting into traffic are the same things, then you're just as bad as these cops, because there's one big thing missing: the traffic. Darting into an empty road is not darting into traffic. Crossing an empty road is not jaywalking. It's not putting anybody in danger. And then the second clue that these cops should have used to exonerate him from this allegation of jaywalking is the fact that nobody complained. There's no skid marks on the road. There's no dead person, and there's nobody called in said anything, dude. And this guy didn't say there was cars anywhere either. So the fact that he's on the other side of the road and the fact that there's no complaining anybody or skid marks or anything else are two things that just completely 100% destroy any suspicion of jaywalking, right? This guy had no reason to be approached. They could have just seen him on the other side of the road, you know what I mean, getting his cola or whatever, and then that's enough right there. You know what I mean? Check the calls, make sure nobody called about a crazy person walking in the middle of the road. And besides, it was 1 a.m. in the morning, dude. You could visibly see there's no cars passing there. It was dead. You know what I'm saying? He did not jaywalk. Plus, again, I don't like the term jaywalking. I don't like it because my name's Jason Zawak. Some people call me Jaywalk. You know what I'm saying? It sounds cool until you think of what jaywalking is and what it means. And also, too, like the lady said in the video, she was like, "Oh man, don't call me a Jay." And then she's like, "I hope my son Jay, like Jason." She's like, I don't know, gets hit by a car. So I don't know. I just don't like the term, man. I don't like that we're reusing it, and I don't like the history of it. I think it's stupid, and I think everybody else is stupid. Anyway, if you made it this far, you're not stupid. Everybody else is. All right, later. Peace.